Recording in progress.
Professor, você quer pedir ele para tirar o compartilhamento?
Ok.
Senão não vai mostrar o seu rosto no momento que você estiver apresentando ele.
Tá bon. Monsieur Sermet, est-ce que vous pouvez retirer juste quelques instants les slides, la présentation, juste pour qu'on peut commencer, et après, dans quelques instants, je vous repasse. OK?
Voilà, d'accord.
Ok. Boa tarde a todos. Começando já o quarto dia, salvo engano, de apresentações aqui do 17º curso de inverno do CEDIM, de Direito Internacional, nessa tarde, nesse início de tarde agora com o professor Laurent Sermet, da Sciences Po de Aix-en-Provence. A partir de agora eu vou voltar a falar em inglês, para que nós comecemos o evento formalmente. Okay? Hello, everybody. My name is Matheus Atalanio. I'm professor here at CEDIM, and we're now delighted to have the presence of Mr. Laurent Sermet, which is professor at la Sciences Po de Aix-en-Provence. He was actually professor at a lot of universities, Université de la Réunion, e também also University Aix-Marseille 3, and which is quite an honor to hear you, Mr. Laurent Sermet, after your excellent speech from lecture of yesterday. Okay, so I'm now passing you in order to begin our lecture.
Okay, thank you. Thank you very much, Professor. It's a pleasure to be with you. So I immediately begin with the subject, and I share the screen. So this is what I will present you. Traditional medicine in international. I've presented the complex subject of state responsibility in international law, and now we change fully the perspective, and I will try to introduce that question to you, which is a question I'm teaching here. Well, teaching, yes, I'm teaching. I'm teaching traditional medicine in international law in Paris, in a special diploma dedicated to ethnomedicine, okay? And I'm in charge of international section, and I'm working with colleagues coming from anthropology, coming from, of course, medical studies. So today, traditional medicine in international law. First of all, I would like, first point, to present the context of traditional medicine, and I would like to give a few ideas. First, traditional medicine, TM, okay, shows a widespread and growing use all over the world, okay? It has much more today importance than before in health system. It has also, that's interesting for us, an economic importance, and it is deeply used all over the world, Africa, and the figure is that somehow 80% of African population uses traditional medicine. Latin America, Brazil, and I will speak about the Brazil later on. Asia, although there is a use of traditional medicine, a widespread use in Latin America and Asia, resulting from both cultural belief and also historical circumstances. And I'm thinking, but not only, of course, to the Indian population of Latin America. Okay, in Western countries like France, the term, of course, traditional medicine is used, but one prefers the expression of CAM, which is CAM for complementary and alternative medicine. Okay, and in Europe, in Northern America, in Australia, maybe I'm sure also in Brazil, the notion of CAM or CAME in English is having a huge popularity because it's an alternative form of medicine. So why this growing interest to traditional medicine? Two reasons. The reason of use. First, this form of medicine is accessible, first, and affordable. And I'm thinking here in regard to developing countries. And in Western countries or developed countries, let's say developed countries, it's understood and viewed as an alternative approach to healthcare. Okay, then we understand that the notion of traditional medicine is, okay, recognized, and there is a huge recognition, but, and this is the main question, I'm not competent, but this is the main question. What is or what are the scientific basis of traditional medicine? What are the scientific basis of complementary and alternative medicine? And of course, that has to be dealt in order to prevent, on one side, an uncritical enthusiasm for traditional medicine, or on the other side, an uninformed skepticism. So here we understand that the subject of traditional medicine is, of course, linked to, first, developing countries, developed countries. Second, is linked to the success, popularity success. And three, it has also a link with, of course, the scientific demonstration of the efficacy of it. So that was my first pose and traditional medicine in context. So that was, of course, very general. I turn now, point two, to another part of the context, that is the international law context. And I mean here, traditional medicine in an international law context, international law perspective. First of all, I would like that there is a kind of openness from international law to traditional medicine related to the values of international law. First of all, we may think, of course, to Article 12 of the famous Treaty for Economic, Social, and Cultural Rights, 1966. And, as you know, this famous human rights treaty, Article 12, is about the human right to health. So we can figure out the link between the right to each of us to health and traditional medicine. Would the right to health be linked to the access to traditional medicine? And this is, of course, very interesting. And I think much more than that, it's the possibility that is open to make a link between human rights on one side and traditional medicine on the other side. Second, as a universal value or international values framework of the subject, of course, the famous Sustainable Development Goals. And I'm quoting here the goals number 3, the SDG number 3, which is linked to ensuring healthy life, promoting well-being for all at all ages. And as you know, this worldwide international public policy is open for the period of 2016 and 2030. There are 17 sustainable development goals, and one of them is interesting for us. What we understand also is the bridge that there is between the right to health, the human right to health, Article 12, 1966, and the Sustainable Development Goals number 3. And within this general goal, namely the goal number 3, the SDG 3.88 is about universal health coverage. And here there is another link to do as a value, international value, which means the link between traditional medicine and the universal health coverage, the universal health for all. Okay, it's not only values, but, and here I have to quote quasi immediately the work that is done by the World Health Organization. Since the beginning of the World Health Organization, namely 1948, okay, there is a deep and clear commitment to health in the constitution of the World Health Organization. And I would like to quote, what is health? Health, says to us, the constitution, is a state of complete physical, mental, and social well-being, not only the absence of disease or the absence of infirmity. Okay, complete physical, mental, and social well-being. So it's interesting here to make a link again between this commitment to health and traditional medicine. Would traditional medicine would be a tool for a state of complete physical, mental, and social well-being. And then, still in the constitution of the World Health Organization, the highest attainable standard of health is a fundamental right of every human being without any discrimination. And here again, the link between traditional medicine and the right to health without any discrimination. Right to health is not only a right of individual like you and me, but it's also the right of the whole people, okay? And the right to health of all people on earth is linked to peace and security and requires full cooperation of states, of individual and state. Okay. So, and I finish with the quotation of the Constitution of the WHO. Health is a value to all. Okay, that was the second point. And that point is about traditional medicine and its possible relation with international law. Okay. I turn now to point 3. And of course, we have to define what are we talking about? Traditional medicine, what is it? And I would like to quote here, you have the slide, a work that has been done under the WHO, World Health Organization. It dates back to 2001, and this book was dedicated to a worldwide survey review of, and it's interesting for us, legal students, legal professors, and legal practitioners, the legal status of traditional medicine and of complementary and alternative medicine. And to go into the book, you learn that there is a triple division: allopathic medicine. Allopathic medicine is what we called Western medicine, or biomedicine, or scientific medicine, or again, modern. Okay, allopathic medicine, allopathic medicine is the modern medicine, as opposed to the traditional medicine, which is open to a very wide diversity of health practices, of health approaches, of health knowledge. There is not only one way to cure people and to prevent illness. There are many ways to heal the people. So there is a diversity of healing. And of course, it is very understandable. And even now, in our very modern perspectives, and I'm thinking to the vaccines, there is not only one vaccine against the COVID-19, there is a diversity of vaccine, like there is a diversity of healing practices in the world with the use of, for example, mineral-based medicine, herbal medicine, but also spiritual therapies. And I'm thinking to yoga. Yoga is interesting because it has been recognized by the General Assembly for its benefit for the well-being. And you remember the well-being. I come back to the slide, the previous slide, we were quoting the well-being as a part of a complete state of physical, mental, and social well-being. So yoga, that has been recognized by the UN General Assembly in 2014, is linked to health in the sense that it helps to achieve a complete state of well-being in the, let's say, spiritual side, not only spiritual, but physical. Includes, so traditional medicine includes spiritual therapies and so on. And then in this 2001 book, World Health Organization edition, okay, there is a third part: allopathic, traditional medicine, and then complementary and alternative medicine. And you understand when you think about the concept that for France, for example, it's preferable to use the expression complementary, as there is, let's say, not much recognition of what is traditional. It's possible, in particular, linked to herbal medicine, herbal practices. When there is outside traditional medicine, it cannot be called as a traditional medicine. For example, I'm thinking to the Chinese traditional medicine in France. Traditional Chinese traditional medicine is not considered as a French traditional medicine, but as an alternative medicine coming from abroad. So in France, complementary and alternative medicine can be understood as supplementary, as being supplementary to allopathic medicine. Okay. And there is also an interesting situation where in some legal system, practitioners are both certified, are both legally competent in complementary and allopathic medicine. Okay, so briefly, there is for the WHO definition 3-part: allopathic, traditional, complementary, alternative medicine. That was in 2001. Still point 3. And I turn now to a recent study that was delivered in 2019, so 2 years ago. There was a World Health Organization global report on traditional medicine. You have the front page of it. And here, the definition is not a standard definition, but it's a quoted definition. And there is 8 major forms of traditional medicine. And I mean acupuncture, Ayurvedic medicine, chiropractic, herbal medicine, homeopathy, naturopathy, osteopathy, traditional Chinese medicine, and Unani medicine that is linked to Southeast Asia, Indonesia, Malaysia, for example. So we understand that, okay, the notion itself is understandable with many perspectives. But, okay, traditional, complementary, traditional, alternative, allopathic, and those 9 major forms. Now, to the, let's say, initial approach. And here I'm quoting a resolution of the World Health Assembly. Okay, I hope it's okay for you to read the resolution. I have printed the resolution in its entirety. Okay, that resolution, 1977, was the 3rd resolution adopted by the World Health Assembly related to traditional medicine. Okay, that was the 30th World Assembly. And I think it can be understood as the initial approach or the initial definition of traditional medicine. And what was interesting for me is at the end of the resolution is paragraph 3. If you can read, you see that the Assembly requests the Director General, blah, 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 investigating technological procedure related to traditional/indigenous system of medicine. So at that time, the notion of traditional medicine was sought as linked to an indigenous thinking, was linked to an indigenous understanding of health, indigenous practices of health. And it is how I do understand it. This resolution is interesting, is dedicated to research. At that time, there was a need for training and research in traditional medicine. And the World Health Organization want to put at equal foot traditional medicine and modern medicine. So it's interesting because it means that there is, let's say, no hierarchy between those two main forms of healing. And I think this is very interesting, and this is a door open to the recognition in international law for traditional medicine, okay? And there is a third element of interpretation of that resolution, which is that at that time, traditional medicine, as being a indigenous medicine, was reserved for developing countries. So at that time, yes, there was an attempt to put on equal foot both the allopathic medicine and the traditional medicine, but allopathic for modern countries, for developed countries, and traditional for developing countries. So I think you can understand how much has evolved the notion of traditional medicine for the World Health Assembly, as now traditional medicine very open, very more open, and you will understand with the further developments I'll do, okay, and also with the integration of complementary and of alternative medicine. I come now to the main question. Is traditional medicine a matter of international law? And here I have quoted, and I don't know if you can see me, a book, if you can see it. That book, I was co-author of it, and you can read here, Let's Know Medicine, Ethnic Medicine, the role of law. And I was in charge of the role of international law in that book. I'd like to make 3 comments. First comment, I'm quoting here a colleague from the Netherlands, deeply involved into international health law. And she said she wrote a very interesting article a few years ago in the International Indian Journal of Law. And she said that international health law may be qualified as an emerging field of international law. So it's not having today, but I'm not talking about traditional medicine. I'm talking about the broad concept of international health law. It's not duly recognized, it's not fully recognized, it's not fully integrated as a discipline of international law. So it's an emerging field of law in international law. So the main question is, and the main problem is it a question of international law? And I would like to make the demonstration, but then I would like also to have your opinion to the answer I will give to that question. Yes, we can say that it is part of international law due to soft law sources, hard law sources, international technical norms of traditional medicine, and also in that package, international public policy related to traditional medicine. So I will now quote those sources of law. First of all, I would like to quote point 5.1, soft law sources of traditional medicine issued by the World Health Organization. And I would like to focus on two of them. There are numerous of them, at least a dozen of them in that book. You will have the opportunity to get to those resolutions. But the two last resolutions were in 2009, a name of the revolution, traditional medicine, and in 2014, name traditional medicine. And in that resolution of 2014, I quote that member states are called to, by the World Health Assembly, are called to, in accordance with their national capacities, national priorities, to adopt and implement the WHO Traditional Medicine Strategy 2014-2023, B or two, to develop and implement working plan to integrate traditional medicine into their national health service, particularly in a perspective of primary health care services, and then to report to the World Health Organization. So there are, as you see, on one side, yes, sources, even if it's only recommendation, but there are sources of traditional medicine, and there is associated to those sources action to do, obligation, soft law obligation, but soft law obligation to execute, to perform in that field. I quote now, and I want to be very direct and very synthetic. I quote now another source of international law, the, let's say, famous Beijing Declaration of 2008. And that declaration indeed quoted some general principle of traditional medicine, and I would like to quote point 1, knowledge, treatment practices have to be respected, preserved, promoted, communicated. So there is a duty to preserve and develop traditional medicine. Second, the famous responsibility of state. Yesterday we spoke about the R2P, responsibility to protect. Here you have a kind of responsibility to protect, namely in the field of health, the responsibility to protect health population, health people. And in that regard, this responsibility to protection of health include appropriate, safe, effective use of traditional medicine. Okay, so it's yes, there is a international law regarding traditional medicine. And then I quote a third point, which is related to some a specific aspect that is really important. I mean, the qualification, the accreditation, the licensing of traditional medicine healers, traditional medicine practitioners. Okay, and this Beijing Declaration, Beijing, China, of course, there is a link between traditional medicine and China and the world. This is very understandable. And here, it's a kind of answer to the question of what are the scientific bases of traditional medicine. This Beijing Declaration took place in 2008. That was 30 years after the previous declaration and famous declaration adopted in Alma-Ata, Kazakhstan. Today, Alma-Ata has become Astana, the name of the capital of Kazakhstan. And in 30 years before, 1978, for the first time, as a huge diplomatic conference dedicated to primary health care services, yes, there was the quotation of traditional practitioners for, let's say, outside the World Health Assembly, the quotation of traditional practitioner, traditional medicine. So we've seen with point 5.1, the resolution of the World Health Assembly. And now, in another context, I mean a state conference context, we see two sources. Those two sources may be analyzed as soft law, but it's not the same soft law. The soft law I've quoted in point 5.1. It's soft law that has been adopted under the auspices, under the responsibility of the World Health Assembly. It's an institutionalized soft law. Whereas in Beijing, like in Alma-Ata, yes, it's institutionalized because there is a conference, but it's much more a political conference. I could, if you want some notion about the Alma-Ata context, I could present the very political side of that conference in Kazakhstan. At that time, but just a door I open and I close it very, very, very soon. At that time, there was a huge competition between two superpowers, communist superpowers, the USSR and the China. And that conference in Alma-Ata was organized in that competitive concept regarding the right to health. So I think it's possible to draw a distinction between what I call a legal soft law, namely the resolution of the World Health Assembly, versus a political soft law, namely Beijing and Alma-Ata. I turn now to a very distinct, a very different point 5.3, which is the famous classification of disease. One of the work of the World Health Assembly is to present for every people, for every population, for every state, an international classification of disease. So here we are in another context. We are in a technical context. This classification is valuable, valuable for health practitioners, doctors, and health services. And it's very precise about the classification of disease. And in 2019, there was a new chapter included into the 11th revision of the ICD. Okay, the inclusion was about the inclusion of Asian or Chinese traditional medicine. Okay, that inclusion was for optional use, and it is in a very technical purpose, and I mean to enable counting of traditional services, traditional medicine services, to measure form, frequency, effectiveness, safety, quality, outcome, cost, comparison with mainstream medicine, and also to give a standardized term nationally and internationally. Okay, here the question is it a source of international law? Yes, but I prefer to retain that it is an international technical norm like the other specialized institution in international law may adopt. Whatsoever, we can now understand that indeed, even if it's for optional use, we understand that traditional medicine is not at all ignored by international law, and namely within the framework of the World Health Organization. I quote now another source, and here we enter into the hard law perspective, and I quote bilateral treaties. And here I'm very pleased because I can present to Brazilian students and colleagues a absolutely unknown treaty. Maybe you will contradict me on that point, but here in France, no one, and I think in Europe, has heard about this China and Brazil a bilateral treaty. There are about 10 bilateral treaties recorded in the UN office, treaty office. There are about 10, and again, that was a part of my contribution to that book. But this treaty is special. This treaty is special, not only because it is a link between China as a superpower in traditional medicine, as you understand, and Brazil, where I have the chance to present that course. No, that treaty is special because it is, and that's the only one. There is no other example of such a treaty. That's the only one treaty in the world that is focused fully on traditional medicine and on traditional medicinal drug. It's a cooperation agreement, so both parties will cooperate between China, Brazil, between their institute. But what you can bear in mind is that that bilateral treaty is fully focusing on our issue of traditional medicine. So that example here shows us that, yes, for a small part, but for a part, traditional medicine in international law is escaping the soft law universe and is entering into the hard law universe, if I may use this image. You have Article 3 about this cooperation in regard to traditional medicine. You have exchange of scientists, you have missions, you have joint research, and I hope you can read this photocopy, this copy, joint research about traditional medicine drug and joint development Okay, joint development, cooperation in preventive treatment, etc., etc. Interesting to have a link to that treaty. Okay, and I turn now to the last source of international law, point 5.5, and I'm leaving the health universe, the health world, and it's possible that there are many examples, but I chose one. Traditional medicine as a cultural heritage of mankind, of humanity. You know that the UNESCO has adopted a convention in 2003, and based on that convention, some classification have retained as intangible cultural heritage of humanity some health practices, and of course acupuncture, moxibustion, and I hope I pronounce it correctly. I doubt moxibustion of traditional medicine, Chinese medicine, has been recognized as a cultural heritage of mankind. So it's not only in the health world that you can find sources of international law. Okay, I turn now to another point. I turn now to the question of public policy, but international public policy. And I come back to the World Health Organization, and I quote that since the beginning, the World Health Organization has adopted two strategies for traditional medicine. The first was for the years 2002-2005, and now we are into the second traditional medicine strategy, 2014-2023. So 10 years. We are finishing in the last part of this decade strategy for traditional medicine. And I would like to quote the main ambition of that public policy, international public policy. First, this policy call for national policy in every state. Second, it calls the state for having regard to safety, efficacy, and quality of traditional medicine and complementary alternative medicine. Also, availability and affordability of access, and then rational use in terms of appropriateness and cost effectiveness. So I think here that we can think about those strategies. What do they say to us? They say to us that for the World Health Organization, the World Health Assembly, that there is no major distinction between the resolution of the Assembly. Remember, I have quoted, I come back, those sources of traditional medicine within the resolution of the World Health Assembly. There is no real distinction between the resolution and those two traditional medicines. There is a link between resolution and international public policy. So for me, yes, in a way, we can say that those strategies can be understood as sources of international law. I'm sure some colleague would say to me, no, it's not possible. I plead the point. And I finish now, in order not to be too long and to allow you to understand and to have some, let's say, a question, discussion, of course. And I quote what I have already quoted. The survey of 2019, the World Health Organization Global Report on Traditional and Calm. Okay. So in that report, I would like to point 3 slides that I took from the report. The first slide is about member states, namely WHO member state, using traditional and complementary medicine in 2019. In green, state using, positively using, and in red, no, not in red, in pink, state not using. And for me, but my eyes are getting lower and lower, I don't see any state not using. So every country in the world in that WHO report is using traditional or calm. And even France, that is very reluctant to it, belongs to those member states using traditional medicine. Brazil, as we said, of course, but we know since we have the proof with the bilateral treaty, China, of course. Second slide of the report that was interesting, I thought, is member state of the organization having a laws, not a, but laws or regulation for TCM. And here it's not fully the same. Okay, it's not fully the same. Green state having and pink state not having. And there are, indeed, we understand, some states that do not have a system of law, like New Zealand, for example, New Zealand or Paraguay, or if I'm not wrong, Peru, you will say that to me, or Spain, or Ireland, or Finland, or Saudi Arabia, or Sudan, for example, or Papua New Guinea, for example. Interestingly, and I doubt this is the case, we see that Bhutan is not included, I doubt. Interestingly, some states didn't reply, and France didn't reply, as it is a white state. No reply, data not available. Okay. Brazil, of course, the most part of Latin America, of America, of Asia, Brazil has regulation. Okay. And third and final slide of the report is about member states having a national policy. So you understand it's not the same. As I did in my own presentation. I presented the, let's say, laws, international laws, and the international public policies. Okay. And we understand that there are fewer states not having in Pinko a public policy, like the United States. United States, as you saw, has regulation, either at federal level or at national level, federated level. But United States has any national policy, national public policy. You have, for example, Sweden. Sweden has no national policy, and Sweden has law regulating traditional medicine. Interestingly, you understand the Bhutan. Bhutan has a public policy. Papua New Guinea has a public policy, whereas in the previous figure, they don't have national law. Okay, I thought those data were interesting for the course. So I conclude now what part, because that was my question, what part of international law in regard to traditional medicine? Okay, we understand that most of, let's say, sources are of soft nature, either soft law or soft law regulation or soft public policies. And here I'm thinking about the two strategies we've seen previously. And I would like to finish with a reflection, that question of international law, national law, international public policy, national public policy, it's working in a double sense. I mean, the international level is fostering the national level, but also the national level is fostering the international level. Thank you for your patience with my English. Obrigado.
Mr. Sermet, it was just an impressive approach. I've actually never thought about this team, and that's quite funny because in my job, in my work here in Brazil, I work with public policy.
Give me 1 second. My cat wants to enter. 1 second. I show my cat to all of you.
Pessoal, se tiverem perguntas, por favor, escrevam no bate-papo que querem falar.
Hello.
Hello.
Excuse me.
There's no problem, Mr. Sermet. I just have this comment, and I'll finish it by a question. It's I work here in Brazil with public policies. I'm chief of staff of federal deputy here in Brazil, and it's just I remembered a few things in your lecture. I had this professor in Paris whom is called Mr. Jean-Marc Touvenin, which probably you are aware of who he is. And
he's a friend of mine.
Oh, it's amazing. It's I remember reading something about I think it was one of his books of articles. I don't remember which. I think it was an article of a book that he has directed or something like that, which has the idea of droit international social, international social law, which is quite it's quite amazing. It's because I've saw that you have done this link between the pact of one of the New York pacts, the economic, social, economic, and cultural pact of 1966, and my idea is how international law can effectively promote public international policies, international public policies. This is, for me, it's and I don't see myself as a conservative student. I just how can you see this? It's just, I mean, I want to hear you, sir.
I think your question is very important, and that was, of course, one of my own interrogation. You know, when you study, when you try to understand the work that is done by the World Health Organization, you realize quickly that they do not pay a huge attention to the legal aspect. No, what they want, it's an assembly of doctors, and they want practical answers. Law is a form, law is a formal mean, and they don't pay that much attention to as we would do to the legal aspect. For example, let's go back to two of the texts I have quoted, namely, okay, the resolution of 2014, okay? That resolution, I thought, as a lawyer, I thought that that resolution would, let's say, open the door to the strategy. You remember? The strategy has been adopted in 2014. In 2014. No. The strategy has been adopted previously, and then the Assembly recognized the strategy. So for me, in the practice of the World Health Organization, there is not much distinction between a public policy and a resolution. They go in the same direction. Okay, the strategy is a huge document, and the resolution is a huge document, but they care about the same question: safety of traditional medicine, efficacy of traditional medicine, quality, so on. They care about the same. Formally, only the resolution are soft law, but I would say that there are indirect soft law via recognition of the resolution. You cannot study only the resolution without studying the strategy. No, they are complementary. That's why you have to give a status to the strategy. It's a quasi-soft law. It's a quasi-soft law.
Yes, Professor Sermet, I can see this. I can also see the link between the strategy, between the resolutions and directives, and all this idea. I can see a link with soft law, and that's why led me to my second question, if it is not a problem to you. It's I just thought your idea of legal soft law and political soft law just quite amazing, because I actually have seen a few soft law which they really do look like more of a law, but maybe there is also some kinds of soft law which looks more of directive or principles, or and when we speak about social international law, and I mean public international law by just for the instance, do you see it more as a legal path or a political path, or you think they are both united somehow?
They are united. They are united. The context is different. The context. Imagine. We turn back to the Beijing moment. China is inviting states to come to share. It's a political event. It's a political event. You go to Geneva, to the World Health Assembly. It's not a political event. It's an institutional event. Every year in the summer, you go back to Geneva. And between May 1 and May 2, okay, the organization has worked on the issues. So it's not the context is not the same. But at the end, so the context would be a political one, an institutional one, but at the end, of course, they gather.
Mr. Sermet, we have a question from one of our students at CEDIM.
Yes.
Lucas, can you speak? Lucas, are you there? I know he has one question. Oh, you can't speak. Okay, so I'll speak for you. Just okay. Lucas' question is: I'm really impressed with this team, sir. How the international law dealing with alternative medicines, for example, indigenous medicines in medical treatments, how we can think about it nowadays according to the international law.
Can you repeat the end?
Yes. How we can think about indigenous medicines nowadays according to international law.
Okay. I think what I've said previously is the scientific basis. Once the scientific test of a, let's say, Indian, Amerindian practice of healing, once the test is successful, then, of course, the recognition by law will come. But I think if we think of terms of chronology of time, the scientific test today comes first. And then the legal recognition. And this is a point I'm teaching in Paris at INALCO, l'Institut des civilisations et des langues étrangères orientales. This is a point I'm teaching on, is the fact that you can understand the scientific test as a test of legitimacy. And you think the legal recognition as a test of legality. For example, in France, we know that a Chinese traditional medicine is working, but it has no legal status. It has any legal status. So despite the scientific test is, let's say, you realized the international classification of disease has included traditional medicine in its classification. France does still not recognize, though the legal test is not met. So if you practice traditional medicine in France, as a practitioner, your status is ambiguous because you don't have the legal test. So for that question, always think to both testers, both criteria, the scientific test, the legal test.
That's really interesting, Mr. Sermet. We have kind of this same problem, even though it's not properly the same thing. but I know we have this problem with chiropractic workers.
Yes.
Here in Brazil, we don't have really a statute of who is the professional, which is the license that this gentleman needs to have in order to practice chiropractic, which for me, for instance, is something that helps me a lot. And we have this ambiguous problem, and it's. I think I share the same opinion of you, sir. I think in a while, maybe in some time, maybe those alternative medicine workers will be formally and legally put on. Let's see if you have another question. No, Mr. Sermet, we don't have another question. I just want to thank you for this amazing lecture, which was for me just quite interesting, of not only for remembering things, but to see things in a different way. It's it's been our pleasure here at CEDIN, and we hope to have you, sir, in another time here.
Yes, in Belo Horizonte.
Yeah, or maybe in our nice beaches in Brazil. I come from a beach town which is called Fortaleza.
Ah, Fortaleza. Okay.
Yeah, and we have a lot of French.
So you are in Fortaleza.
No, now I'm in Brasilia. I'm in the capital.
Ah, in Rio. Ah, no, Brasilia.
Brasilia, yes. But tomorrow, thanks God, I'm being back in my hometown.
Okay.
Professor, can you only take off the presentation in order for students to take a picture?
Okay, that's it.
Because I know they will ask. And okay, I think
when there is a slide,
I think that's time enough.
When there is a slide, that the book. Did you see the book? What did you see the book I have presented?
Yeah, I saw. Yes.
Okay.
So 1, 2, 3, and I'll take. Okay. 1, 2, 3. Okay, Professor Sermet, it was just an amazing evening for you, even for us. Okay. Bye-bye, and hope to see you at Fortaleza, maybe.
Okay, hope so. Bye-bye. Bye-bye to all of you.
Thank you, Professor.
Bye-bye.
Thank you, Professor. Bye-bye. Thank you.
Bye. Thank you.